I'd like to start by thanking all the trial partners for being here. It's been a great workshop so far, and in particular, thanking Sasha and Mohor for the invitation to participate in this training. As we are a bit behind our schedule, I'll try to be as brief as possible, okay? And my aim here is a little more modest than in the previous panel. So I'm going to make a short review of Portuguese case law regarding the liberty, the freedom of expression of legal professionals. So cases that have been decided in Portugal. And I'm going to bring to your attention 4 cases. The 2 first cases are related to the freedom of expression of judges, and the 2 final cases relate to the freedom of expression of lawyers. So I'll do one at a time, and in each of them, I'll highlight a couple of points that might be useful for us to retain and to ponder later on if there's the time for that. So the first case is a case that concerns what the limits of the reserve duty imposed to judges are. And more specifically, the question is whether a judge can comment with the parties to the proceedings any question that relates to the same proceedings in the context other than that of a judgment. So in this case, a judge, after a hearing and before the decision, made some comments to the defendants and led them to believe that they would lose the case without the judge or having decided yet. And on the basis of this, the judge was subject to a disciplinary sanction by the High Council for the judiciary. The judge was not happy, and therefore he appealed to the Supreme Court. And the Supreme Court maintained the decision and considered that the judge had breached the duty of reserve. And what is relevant about what the court said are 4 points. The first idea is that the duty of reserve constitutes restrictions on freedom of expression of the judge. And this is based on the independence, the impartiality of the judge, and social trust in the administration of justice. The second idea that is important is that the duty of reserve prevents a judge from issuing valuation judgments on any lawsuits in general, but in particular on those in which he or she is in charge of. So it requires that judges refrain from making comments or remarks that can reasonably be interpreted as prejudices in relation to the matter to be decided or to the parties, and thereby prevents the decision recipients and the general public from creating mistrust about their decision and affecting the community's confidence in the administration of justice. The third point that is important to make is that in this case, the Supreme Court of Justice concluded that, taking into account that it was the judge who addressed the defendants and that the conversation was maintained before people who were not involved in litigation, it was impossible to conclude that the facts in question were devoid of disciplinary relevance. And finally, in 4th place, the Supreme Court also concluded that the fact that the comments referred to were given in the courtroom does not in any way detract from the necessity to maintain an image of impartiality and exemption in the administration of justice. So in this case, both the High Council for the Judiciary and the Supreme Court referred to Article 10 of the European Convention. And on this basis, they made a narrow reading of the duty of reserve as enshrined in the duties of the statute of magistrates. They did, in a way, what it's not a proper consistent interpretation, but they tried to do consistent interpretation in this case. And it's important to take a look in relation to this case, what is considered to be that duty of reserve according to the statute of judicial magistrates. And so according to the official, the superior High Council for the judiciary, they claim that it is based on the protection of impartiality, independence, institutional dignity of courts, and on the citizens' confidence in justice. and it combines those grounds with the freedom of expression. And this covers, in essence, statements or comments, both positive and negative, that judges make, which involve evaluative assessments about cases they're in charge of. On the other hand, this also applies to all types of pending cases, and cases which, even though they have been already decided, deal with undeniable topical facts or situations, in case the judge is responsible for them, or in case the judge is not the judge responsible for them. Taking into account all these rules that in readings of the duty of reserve that the High Council for the Judiciary has made, there are two recent cases which are not court cases but everyday news that are actually relevant. The first is concerned a judge, a criminal judge, who was subjected to disciplinary proceedings for having given an interview in the television about a case he's responsible for. And this case in particular is a very high profile with lots of media coverage case. And therefore he raised suspicions about the assignment of judge to the second phase of that same case. So that's one of the cases that was in the news recently. The second is more interesting because it regards comments made on Facebook, which has been covered in other sessions, in sessions of our project before. So the case concerns Judge Clara Sotomayor, who is a justice at the Supreme Court of Justice, and she wrote some comments on her Facebook page regarding the murder of a 9-year-old child by her father. When it was made public that the father had killed the child, she, who had no connection to the process regarding the custody of the child at all, made a post on Facebook stating, and I quote, "How many times has this girl told the court that she didn't want to go to her father's house? Was there a process of parental responsibilities with shared custody? Was the child heard? This has to be investigated to the end. It is necessary to know why the court ordered shared custody." So at the same time, these comments generated a wave of criticism from lots of judges and lawyers who felt that the judge had violated her duty of reserve. But she replied to these comments saying that she had not violated any rule and that she was only exercising her right to civic participation as a citizen. In any case, whichever our position on the topic is, the fact is that the High Council for the Judiciary, in one of its decisions, although it decided not to open disciplinary proceedings as such, it did decide to apply a sanction of an unrecorded warning to the judge. And so this is the first case in related cases about the duty of reserve of judges. So now let's move on to the second case about judges. Here, it's about, the case is about the possibility of a judge who is responsible for, again, a process that involves lots of media frenzy. In the case, a case that involves a former prime minister that was charged with corruption and some other types of crimes. Can that judge make comments about the process on public television without questioning his impartiality? So this judge, a judge from the Lisbon Court of Appeals, was, at the same time that he was a judge, he was a television pundit. And in this case, which involves the former Prime Minister José Sócrates, part of the decision of the Court of Instruction of First Instance was appealed to the Court of Appeals, where this judge is a judge. And he was assigned to the case. He had, however, made comments regarding this whole investigation operation in national television, in the TV show where he was a pundit. So As a consequence, the public prosecutor's office asked the Supreme Court of Justice to remove the judge from this process. And the Supreme Court of Justice actually agreed with the public prosecutors. And among other statements, the decision is actually long. It is important to highlight that they said the following. It is unquestionable that the aforementioned intervention by the judge had public repercussion and media resonance. And so from an objective point of view, it is to admit from common sense and experience that any average citizen of the community can contest or put in question the impartiality of the judge. In this case, however, there was no judicial dialogue, there was no interpretation of the European Convention or of the Charter in any way whatsoever, neither by the High Council for the Judiciary, nor from the Supreme Court of Justice. And with these two cases, we close the first part, which is a part about the freedom of expression of judges. And now we move on to the two other cases, which I will analyze jointly, which are about the freedom of expression of lawyers. In these two cases, the courts found liability against two lawyers for, in the one case, defamation, and on the other case, for attacking a person's honor, in respect of two judges on the account of documents drawn up by the lawyers in their capacity as representatives. So in the first case, what happened was that the lawyer sent a letter to the Council for the Judiciary complaining about the conduct of a judge. And that judge had allegedly committed certain procedural irregularities during a hearing. And in particular, the complainant had noticed an atmosphere of great familiarity between the judge and the defense counsel. The council decided, however, to take no disciplinary action on the judge. And therefore, the process from the lawyer side ended there. The judge, however, decided to lodge a complaint for defamation against the lawyer, alleging an attack on her reputation and honor. And the court of first instance actually found the applicant guilty of aggravated defamation and also ordered the payment of a compensation. So the judges found that the accusations made against the judge had overstepped the bounds of permissible criticism. The lawyer tried to appeal to the Supreme Court of Justice, but without any success. The second case involved two persons of Roma origin who were represented by this lawyer, who on their behalf lodged a complaint against the judge for defamation, for racial discrimination against them because of comments made by the judge in a judgment concerning these two people. The case was discontinued by the public prosecutor, and therefore it had no decision that was favorable to the complainants. And these two people, also represented by the same lawyer, brought a private prosecution for defamation, claiming compensation. But this complaint was declared unfounded by the Court of Appeal. What happened then was, as in the other case, the judge brought a civil action against the lawyer, arguing that in his capacity as representative of the parties, he had knowingly lodged an unfounded criminal complaint against her. And the lawyer was ordered to pay 10,000 euros with interest to the judge. These cases were appealed to the two of them were appealed to the European Court of Human Rights. And in these cases, the court noted that the decisions finding the applicants liable constituted interference with their freedom of expression. That interference pursued two aims: protecting the reputation and rights of others and judges, and maintaining the authority and the impartiality of the judiciary. However, the court considered that the reasons given by the domestic courts to justify the applicants being liable had been neither relevant nor sufficient and had not corresponded to a pressing social need, and therefore the interference had been disproportionate and had not been necessary in a democratic society. So the Portuguese state was condemned to pay damages for this for these two cases. In particular, one of the arguments made was that these accusations were only transmitted to the Judiciary Council, and therefore they were not made public, and so the damages to the alleged reputation of the judge would be very limited. And on the other hand, however, it would produce a very strong dissuasive effect for the legal profession as a whole, especially when it comes to lawyers defending the interests of their clients. So, taking into account all the two sets of cases that we have looked at, what can we conclude from one such analysis? Well, we can conclude on the one hand that the reading that the national Portuguese authorities, namely the Judiciary High Council and the Supreme Court of Justice, make from the duty of reserve is a rather strict one. And so that is to the expense of freedom of expression of judges, of course. And that also involves Facebook posts, which were allegedly made on personal capacity as civic intervention. On the other hand, when it involves lawyers and the freedom of expression of lawyers, the Portuguese judges seem to be rather strict, and they seem to be very, how to say this, but they seem to easily draft or be able to make the actions of the lawyer correspond to breaches of the honor, to defamation, and I'm not sure if these two trends go hand in hand together, or if the second one in particular is not a kind of a corporative reaction to this type of freedom of speech. Well, I've already taken too much time. That sums up what I had to present to you, and I remain available for all your questions. Thank you very much for your attention.
Thank you very much for this very detailed account on the Portuguese case law. It was very useful, and I'm sure that the Romanian lawyers who are present here drew some conclusions as to the universality of the interprofessional dialogue or lack of dialogue. And I will immediately turn to Federica Casarosa to have an account of the Italian case law as well.
Thank you very much. I prepared a PowerPoint, though I think that I will go quicker and in the matter of time if I just go through my presentation, and then I will circulate my PowerPoint later on, and thanks to Mohor and on the Apogee platform. First of all, thanks a lot for the invitation. I will try to focus on the three cases that are also available on the CJC database regarding freedom of expression of the judges, of judiciary in general. And they are, it's very interesting that I can connect with the Tiago presentation regarding the duty of confidentiality and the, of course, the emergence of problems regarding the use of social media by judges in personal capacity. So here I have to make a step back and take a reference to the Italian constitutional principles that apply to this type of cases, which are Article 21 on freedom of expression and Article 101 and 111 of the Constitution, which are dedicated, the first one on that clearly states that judges are subject only to law, and the other one that provides the fair trial guarantees that are applicable to in the matter of justice. So the issue is that the balancing between these two principles is very difficult, because either we can say that the judge speaks only through his or her decisions, meaning that there is no external interference because it's only subject to law, but it's not subject to any other power. But it's also a problem regarding the fact that judge is entitled to express also his or her opinion outside their decisions. So it's a personal capacity. So the first decision that I will quote and I will refer to is the Constitutional Court decision 100, 1981. So you can think that there is a very, it's not a very recent decision. And in this case, there was the first intervention by the Constitutional Courts addressing if and how the judge can enjoy the freedom of expression. And in this case, it's clearly said that he enjoys the same rights as any other citizen. However, it is subject to the limits prescribed by law based on the constitutional principles. So the reference is to Article 101 and 111. So according to the constitutions, judges must be impartial and independent. And these values must be protected, not only when exercising judicial function, so in their professional capacity, as Judge Sietske was mentioning earlier on, but also as a deontological rule, in order to avoid that independence and impartiality can be doubted by citizens. So these external appearance of independence and impartiality. This is the important element, because in this case, the fact that it's not just institutional, but it's also functional justification for this impartiality means that in order to be effective, it should also be that the judge should appear to be independent and impartial. So there is a strict interpretation, for instance, for the duty of confidentiality. So the judge must refrain from any expression which in terms of content and manner undermines or risk undermining the appearance of impartiality. So in this case, however, we have a secondary law intervention that was amended in 2006 in Italy that also have the effect of clarifying how the duty of confidentiality should be qualified as an offense, so by the judge. And in this case, we point to a decision that is very recent, because it's 2020, that addressed the case of a public prosecutors who took part in a documentary film addressing certain aspects of a judicial case. And this case had really great media resonance at the international level. So the involvement of this judge was based on the fact that he was the preliminary investigation judge in the case. And the documentary film was shot during the trial in the first instance. And then the screening took place shortly after the start of the appeal proceeding. So the fact that the judge participated in this document, in the shooting, was still in the activity. So within the period that is currently working for the proceedings. So it's not outside the time of the proceeding was completed, or at least getting to an end. So the problem was that if this participation constituted a breach of the duty of confidentiality, and who is the harmed, what is the problem of the offense in itself. So the issue is that the legislative decree number 109, 2006, that is the reference, that is a point of reference for these decisions, speaks about duty of confidentiality and requires two criteria. First of all, there should be a breach of confidentiality in the acts of the proceeding covered by secrecy, but also in the affairs that are still ongoing or not already defined. So we have an element regarding the period and the moment and the content that is disclosed. And in this case, the Supreme Court affirmed that there was a breach of confidentiality. However, we have a second criteria. That is the disclosure is likely to unduly prejudice the rights of the others. So there should be a problem of prejudice. And in this case, the Supreme Court took into account that the case did not affect anyhow any subject. So there was not, should be, let's say that these harm should be concretely capable of compromising the interests of to the credibility of the judicial function. But in this case, the Supreme Court affirmed that the judge only presented the ways in which they build the criminal accusation hypothesis. So it was not something that was disclosing, it was not making the judiciary, reducing the credibility of the judicial function. So it was not qualified as such. So in this case, although there was a breach of confidentiality, we may say that there was not a sanction, and the appeal before the Supreme Court was dismissed. The other two cases that are connected, because they are both related to social media, are dated back to 2017. And in one case, there was a judge participating in a heated debate on a discussion forum on a blog. And in that case, it was problem was that the content could be qualified either as professional, as an expression of the professional in the professional activity, or as a personal in a personal capacity, because in this case he was defending the work of the public administration. And in particular, he stressed that a climate had been erroneously painted in which all lawyers, without distinguishing between prepared and valid lawyers, was the innocent victim of despot and self-referential system. So there was a kind of problem regarding how the lawyers could be qualified. And so there was a difficult task of understanding if the judge was able to criticize the judicial activity of colleagues, or say not colleagues, but also legal professionals in a mailing list. And if the judge participating in this mailing list was within the exercise of its function or not. And in this case, the Supreme Court, the disciplinary section of the Judicial Council before, so the first decision, decided that there was a damage to the reputation of the judiciary because there was a common and serious incorrect conduct, and the judge should have avoided to participate in a discussion forum due to his position, and more so in the matter of concerning the administration of justice. But the court of the Supreme Court instead addressed the alleged defamation, and they decided that, given that, because it was qualified as defamation, given that the victim of the defamation could not be identified, the crime could not be applicable. And as an obiter dictum, the court addressed that the exercise of freedom of expression of the judge may not be qualified as the exercise of judicial activity, also in cases, as the circumstances of the case, matters related to administration of justice. But in this sense, the court affirmed that the role played by judges must not imply an excessive limitation to their ability to participate in the public debate. And this really, it's interesting because it points back to what Tiago was mentioning regarding the Claras de Mayor case. So how and when they express their opinion in the personal capacity or not. But in the exercise of their judicial opinion, this may be only in the exercise of their judicial opinion, they may be limited, but again, according to strict interpretation. Last case, and I will finish up, is the defamation occurring again, an allegedly defamation case against a judge who published a post on Facebook. And in this case, the disciplinary proceeding ended up in nothing, because the sanction was of minor importance. But the issue was that the case went to the Supreme Court, and instead the Supreme Court overtook the decision of the disciplinary section and clarified that even so the defamation was not perceived as an offense by the victim, it was not to be disregarded as an offense. So it is important that what counts is the seriousness of the offense from the point of view, from the objective point of view, regardless of the attitude of the victim. Because in this case, we are speaking about, again, this is a different weight that is given, because the use of a judge cannot be the use of social networks, and in this case, the defamation cannot go unpunished. So, because the defamatory content published online could damage the reputation of the judiciary as an institution. So in this case, we have a different perception, a different opinion by the disciplinary section of the Judicial Council and the Supreme Court. Finally, I would like to point out that on social media, there has been a recent development, because the Council of State in March 2021 adopted a resolution on the use of electronic and social media by administrative judges. So just for administrative judges, because this is the separation of judiciary proceedings in Italy. So we have civil, criminal, and administrative on the side. And in this case, we have these guidelines. And in particular, we have, I would like to point just to 2 items. First of all, the guidelines address friendships and connections created online, because they can also be problematic in terms of the evaluation of incompatibility for the proceedings. And these are important because they say that they are not to be taken into account, because obviously judges can be also public figures that could have more friends than they really do. And also, and this is really connected to our work, is that every administrative judge has the right and duty to receive specific trainings on the benefits and risks of using social media. So in this case, we are really going in the correct direction, because we already have this type of training for judges on these problems and addressing also these issues. Thanks a lot. This is my last point.
Thank you very much, Federica. And without further ado, I will go to Mohor, and maybe we will have time for some questions. If you can think of them already, please write them in the chat box for the panelists to already see them, and this would speed up probably our discussion. Thank you.
Thank you very much, Luca. You probably hear me well. I thought I wanted to present you 5 different cases, but I'm not going to, because you can find them in the Apogee e-learning, trial e-learning platform. So I'll just actually give you 2 observations on the Slovene case law, which are quite, they are nothing special. And they are that sometimes Slovene authorities really struggle to adequately address the freedom of speech aspects of the case, but sometimes they do a really good job. And now I would like to turn to the Ethical Commission of the Judicial Council. And I'm not going to present concrete cases, but I'm going to start with an order that was issued by the Judicial Council, saying that a negative decision of the Ethical Commission, meaning that if an Ethical Commission finds a violation of judicial ethics by a judge, this decision goes into the judge concerned personal file, to his or her personal file. So the question is, for example, let's take a very simple example of a judge who publicly criticizes a fellow judge, and the Ethical Commission finds a violation of judicial ethics, and this decision of the Ethical Commission goes into his personal file. So the question that arises is whether this constitutes an interference with freedom of expression of this judge. And according to the Strasbourg court in Panioglu versus Romania, it actually does. And the Strasbourg court has said that this is true, even though the opinion has no concrete bearing, no concrete influence on the position of the judge, on his salary, etc. But it can affect negatively the prospect of promotion. It can negatively affect the evaluation of judicial service. And this is, according to the Strasbourg Court, enough for an interference. So if we accept this, that if a negative decision of the ethical commission, if it goes to your personal file, constitutes an interference with freedom of expression, then there are, of course, very important consequences. And I'll name only one, which is that, of course, this decision of the ethical commission then has to be must be able to be challenged before independent and impartial court or tribunal. So here in Slovenia, we have at least according to the legislation, there is no legal remedy or judicial remedy against the decision of the ethical commission. Even though, as the Strasbourg Court said, this constitutes an interference with freedom of expression. Well, this is problematic, but the issue can be solved by the Slovenian constitution, which in Article 157 says when there is no explicit judicial remedy, in short, a person whose fundamental rights, constitutional rights, are interfered with by an act of some authority can challenge this individual act before the administrative court. So the Slovene constitution seems to offer a solution here. But in my opinion, I think we're before a decisive step. And that is, we can continue to insert the decisions of the ethical commission in the personal files of judges. But then, of course, we would have to allow judicial review of these decisions. And this would, of course, fundamentally change the institutional framework within which this commission is working, because the courts would have the final say over the ethical dilemmas. Or the other option is to simply repeal the order of the Judicial Council, which says that the negative decisions of the ethical commission should go into the personal files, and by that we could allow the ethical commission to return back to ethics and leave human rights, freedom of expression, to courts. But as you probably notice it, this my argument, my conclusion is based on an assumption that the interference with freedom of expression only occurs when the negative decision is inserted in the personal file, and that it would not occur if it wouldn't end up in the personal file. So I think one could argue even further. We could say that irrespective of whether the decision of the ethical commission goes into your personal file, it can affect the prospect of promotion, especially, or I don't know, your judicial grades, especially in a small community of lawyers as the Slovene one is. So my question is judicial review of the decisions of the ethical commission inevitable, especially if we take into consideration the way how the procedure before the ethical commission functions. The commission actually hears a concrete case against a concrete judge and issues a concrete decision. So maybe we don't need to answer this question, but I think that instead of answering this question, I think it all boils down to what we want the ethical commission to be. If we want it to be a quasi-disciplinary disciplinary organ, or we want it to be a forum of constructive dialogue between the judges on ethical dilemmas of their work. And I'll leave you with this. Thank you for your attention, and I would like to thank everybody, especially the speakers and also the participants, for a very, very stimulative afternoon. I'm very glad that there are almost 30 people still here, even though it's getting darker in Slovenia. And without further ado, I would like to pass the floor back to Raluca for the Q&A session. Thank you.